More witnesses today to explain the discrepancies in Corona SAL-ends. Good afternoon. It is day 32 of the impeachment trial of Chief Justice Renato Corona. I'm Natasha Gutierrez reporting live from the Senate for Rappler.com. Today, there's been a lot of conversation in the Pulse Asia survey that released its results earlier this morning. The report says that 47% of Filipinos think that Corona is guilty. The prosecution says that the results somehow validate that they have presented their case well, while the defense has expressed hope that this will not sway the decisions of independent senators. Presiding Officer Juan Ponce Enrile said earlier this morning to the media that he will base his decision on evidence presented. Now, also yesterday, the defense presented 4 witnesses to explain why 5 properties of Corona were not listed in his statement of assets, liabilities, and net worth. Carlo Alcantara, head of Quezon City's Register of Deeds, testified that 4 properties were no longer owned by Corona, while the Makati City Assessor Mario Badillo testified about the accuracy of the entries of Corona in his SAL-ends. He said that the assessed value and fair market value that he listed in his SAL-ends were based on determined market values provided by his office. Now, the defense also discussed the column properties of Corona, which the Corona couple purchased in 2004, but they did not list this property in Corona SAL-end until 2010. Corona's counsels argued that the delayed declaration was due to defects in the unit, and because of this, Corona did not declare the property in his SAL-ends because they were still sorting out the issue. However, the defects were sorted out by 2010, hence the declaration of the property then. However, senator, judges, and the prosecution say that even if he had technically not yet accepted the unit, it should still have been listed in the SAL-ends as it has some sort of value. Now, another issue raised yesterday was whether SAL-end errors constitute an impeachable offense or not. The defense argues that old guidelines on listing properties or assets in SAL-ends were vague. However, the prosecution says that these errors were intentional. Both sides will submit a legal memorandum on this issue. Now, also yesterday, the impeachment court denied the defense motion to cite House Majority Leader in contempt for allegedly threatening Navotas Representative Tobias Tiangco. Tiangco testified for the defense and spoke of the way the impeachment complaint towards Corona was organized. Again, lead counsel Serafin Cuevas will not be in the proceedings today as he is still ill. Defense counsel Joel Bodegon is expected to again take his place. Witnesses to explain how Mrs. Corona gained control of Basa Guedote could also testify today, specifically Regional Trial Court of Quezon City's Clerk of Court, as well as the Sheriff of the Court. They are expected to testify on this issue. Stay tuned at Rappler.com. The trial starts at 2 p.m.
continuation of the impeachment trial of the Honorable Chief Justice Renato C. Corona of the Supreme Court is hereby called to order. We shall be led in prayer by Senator Teofisto Gingon.
Heavenly Father, once again we come before you to pray that you may bless an important task, the performance of our earthly mission of unearthing truth and dispensing justice. Yet we come before you to dedicate this task and hope that you find delight in what we do in this chamber. Lord, your word reminds us all that you detest, despise, and hate lying lips. Open our eyes when such lips come before us. Unmask them for us and protect the ears of those who shall hear the words from such deceitful mouths. Your word reminds us too that you delight in persons who are truthful. May you find delight in the process now taking place in this chamber. May you find delight in the words of those who come here and bear the truth before us. Give us ears and minds that discern truth amid lies. And may our human efforts be rewarded with the discovery of the truth in which you delight. With humble hearts we pray. Amen.
Amen. Secretary will please call the roll of senators.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alad Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revillas, Soto, Trillanes, Villar, the Senate President.
With 16 senators, senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silence under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the March 19, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the March 19, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will now please call the case.
Case number 0022011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, may we ask the parties to enter their appearances for the prosecution?
Good afternoon, Mr. President. For the prosecution panel of the House of Representatives, same appearances. We are ready, Your Honor.
Noted. Defense.
Good afternoon, Mr. President and members of the impeachment court. Same appearance for the defense.
Noted.
Mr. President.
Majority Floor Leader.
Mr. President, before the continuation of the cross-examination of defense witness Mr. Ben Slim, may we recognize Senator Teofisto Gingon III.
The gentleman from Bukidnon.
Thank you, Mr. President. Just clarificatory questions. This is addressed to the defense. Ano po, naguguluhan lang kami, so I'd like to just be clarified, no? In 2010, the Corona sold two properties. One Ayala Heights, which was sold for 8 million, and another La Vista, which was sold for 18 million.
That is correct, Your Honor.
Thank you. And in his 2010 SALN, nakalagay 4 na kondo. So, yung kondo 4 and 5, may note nakalagay sa SALN, we sold 2 parcels of land in Quezon City to pay for the loans for the condo units to pay for the condo units 4 and 5. Am I correct?
That is what appears in the SALN for 2010, Your Honor.
Okay. And this condo 4 and condo 5 are Bonifacio Ridge, condo 4, and Bellagio, condo 5. Am I correct?
Correct, Your Honor.
Okay. My question lang is, if the Quezon City properties were sold in 2010 to pay for the condos, the condo 4 and condo 5, condo 4 po was paid, fully paid in 2004. And condo 5 was paid in 2009. So actually, when you sell something, you get the money and use it to pay for the condo. But in this case, nauna po yung purchase ng condo before selling of the Quezon City lots. Could you please enlighten me on this?
If Your Honor, please, this should actually be the subject of testimony. However, if you...
Forthcoming testimony?
Yes, Your Honor. However, if may I invite your attention to the note, we sold 2 parcels of land in Quezon City to purchase / pay the loans for condo units 4 and 5.
Okay.
So, the proceeds were used to pay for the condo and the loan, Your Honor.
And maybe the loans,
yes,
the
but,
loans, not the condo, because the condos were already purchased.
Yes, Your Honor. There must still be outstanding loans, Your Honor, which were paid by the proceeds of the sale. Anyway, this will have to be covered by testimony, Your Honor.
Yes. But in 2010, you don't have liabilities anymore. No loans.
But there were pre-existing liabilities, Your Honor, that were extinguished or paid for by the proceeds of the sale.
Even in your 2009, wala na pong liabilities.
Well, as I manifested, Your Honor, this would better be testified to by
Let us wait
witness,
for the evidence of
Yes, Your
the defense to be
Yes, Mr.
presented.
President. Okay, I would like to thank the defense for trying to clarify the matter. Thank you.
Thank you.
Majority Floor Leader.
Yes, Mr. President, before the business of the day, may I just call the attention of the Secretariat for probably a typographical error on page 9 of the journal as manifested by Senator Arroyo to this representation. On the 5th line, do not, remove do not, because what he said was we have the law. He did not say we do not have the law. That's all, Mr. President.
All right.
For the record.
If there's no objection, make the proper correction.
Thank you, Mr. President. May we now continue with the cross-examination of defense witness Bensley.
The prosecution, is the witness here already?
Yes, Your Honor, but just a short manifestation, Your Honor, before we continue. May I just inform the Honorable Court that our Chief Defense Counsel is still indisposed, Your Honor. Chief,
well, we take
Justice
note of that, and we hope he will get well.
Yes,
I
Your Honor.
understand he has a vertigo.
Yes, Your Honor. That is also our prayer, Your Honor.
Just tell him to take circ.
We'll convey that, Your Honor.
Yes.
Thank you.
And do exercise. That will disappear.
Yes, Your Honor.
If he needs assistance, I will help him. I had that problem once upon a time. So, anyway, is the witness here already?
Yes, Your Honor. May I, in this regard, may I now call on Attorney Judge Roy, Your Honor, for the presentation, for the continuation of the testimony of the witness, Ben Slim.
Judge,
Your Honor.
Attorney Roy.
Thank you, Your Honor. Mr. President.
Is Attorney Roy a judge?
No, Your Honor.
Okay.
I was a dean at one time. But
Yes, you see, I know your grandfather very well, so I'm quite familiar with the Roy family. So,
thank you, Your Honor.
So,
may I have a minute to summon the witness, Your Honor?
all right.
Your Honor,
You have a minute.
Thank you, Your Honor.
Oh, wait.
before
Okay,
No, after na.
Defense.
Yes, we just like to manifest that we were supposed to start our cross-examination, but after going over the documentary exhibits presented yesterday, we have decided that we will no longer propound any cross-examination questions.
So no cross.
No cross, Your Honor.
So we'll dismiss the witness.
Your Honor, if I may,
Yes.
the witness was asked to return because there were certain questions left unanswered. Now, he has brought other documents which may be of interest to the court.
All right. The leave of court is granted.
Thank you, Your Honor.
Bring the witness for further direct examination and subject to cross by the prosecution if there's a need for it.
Your Honor, may I address the court? Anyway, everybody seems to be here,
Yes.
so as not to waste time and
Proceed.
to avoid the awkward silence, Your Honor. Yesterday, I believe one of the questions had to do with when the keys or when the unit was accepted.
Yes.
And if I'm not mistaken, the witness is in possession of a document which will establish that issue or that fact, no? He's here, Your Honor.
All right. Under the same oath, the witness will testify for a further direct examination.
With your permission, Mr. President, I would like to propound a few additional direct questions. Mr. Witness, good afternoon.
Good afternoon, Your Honor.
Thank you for coming back.
Thank you, sir.
If you recall yesterday, the court asked you if you were aware of when the unit was accepted by Mrs. Corona.
Yes, Your Honor.
Okay. Can you tell us if there is anything in your records that might show us when the unit was accepted?
Basically, Your Honor, we have a master lease based in our management in the admin office. So we have a master lease for that, sir.
Now, if I recall yesterday, Senator Judge Pia Cayetano asked you how you are informed to begin collecting dues. Can you explain that to us, please?
We just referred to the master lease, Your Honor.
What is contained in the master list?
The master lease, Your Honor, is the unit itself, the registered owner, and the acceptance date.
Do you have a copy of this master list with you?
Yes, Your Honor.
Can I see it, please?
Produce the document if you have it, Mr. Witness.
Your Honor, may I make of record and may I invite counsel for the prosecution. The witness is showing us a document which he says is the master list. Can you please tell us, Mr. Lim, what is this image we are looking at?
The image that we are looking at, sir, is the master lease. This is the monitoring in our admin office. This states when is the exact date that we will bill the unit owner for the association dues.
Your Honor, may we request that this document be marked as exhibit number...
Is that document dated?
Oh, is it date? When is the date of this document, Mr. Lim?
This is as of August 12, 2009. But this is only computed... August 12, 2009, Your Honor.
So that list covers all unit holders in that particular condominium as of that date.
Yes, Your Honor.
Okay.
When did you get this copy or when did you produce this document, Mr. Lim?
Basically, this is in our records, sir, because I'm just in by 2010.
Yeah, but when did you get this document from the records? When? When did you get this document? When did you get this copy?
This is based in our records, sir.
Yeah, when did you get it from your records? Yesterday, today, last year? When did you get it?
The question is, when did you get that? When did you take that record from your
files
to bring it to this court?
Just yesterday, Your Honor.
All right. So
Only yesterday.
yes.
Yes, Your Honor.
Your Honor, just a manifestation.
Yes.
The document which was presented appears to be a printout, a computer printout, and not a normal document. But it is.
It is a printout which, yes, we that is correct. That is a
But,
correct observation.
I
Your Honor.
suppose Ayala has computerized all its files. I don't think they're keeping hard copies as files in our modern world. You know?
If I may be allowed,
Yes.
Mr. Lim, who produced this document? Who? Who had it printed out?
Me, Your Honor.
You. Who operated the computer to print it out?
Me, Your Honor.
Whose computer did you use?
Mine, Your Honor.
I hope that will satisfy the court as to the authentication of the document, Your Honor.
Is that computer printout found in the master computer file of Ayala?
This is the copy of us from the admin office of the association, Your Honor.
Okay.
If I may have this marked, Your Honor, we adopt this as Defense Exhibit 212.
Mark it accordingly. Thus, it contains the list of all the unit holders.
This particular document only contains an excerpt, Your Honor, the relevant excerpt pertaining to the issues in this case.
Yes.
But it was drawn from a list which contains all the
And,
members of the corporation.
And it does not state the exact date when the unit was accepted by Mrs. Corona.
I will try to extract that from the
All right,
witness, Your
go
Honor.
ahead.
Thank you. Mr. Lim, would you be so kind as to explain? There are several columns on this sheet of paper. Will you please be so kind to explain what those columns are?
The particulars indicated here are the unit itself, which unit they are, and the unit owner, who are the registered owner, and the acceptance date, when is the unit accepted, and the deemed acceptance date. This is where the developer policy when to the owner to accept the unit, and the remarks.
Mr. Lim, can you tell us if this list includes the unit of Mrs. Cristina Corona?
Yes, Your Honor.
Can you identify the entry which shows the unit of Mrs. Cristina Corona? And I invite counsel to...
Your Honor, at this point, I'd like to object. I believe the witness is incompetent, having testified yesterday that he was only employed in 2010. The dates appearing in the record would be 2006 and 2009, Your Honor.
This only he's testifying on the record.
Yes, Your Honor, but it would be hearsay, Your Honor.
I don't think he's going to vary the contents of the record. He's being asked questions what is recorded in that document. So the witness may answer.
Thank you, Your Honor. Mr. Lim, can you please tell us if the name and the unit of Mrs. Corona appear on this excerpt of your records?
Yes, Your Honor.
Can you tell us what is the date of acceptance? Because you mentioned earlier that this record contains the date of acceptance. Is it indicated there?
Yes, Your Honor.
What is the date of acceptance, Mr. Lim?
Based on this file, sir, is August 12, 2009.
So your file says that Mrs. Corona accepted the unit on
August 12, 2009.
August 12, 2009. Do you know, Mr. Lim, where this information comes from?
This is from the developer.
You mean to tell me that the developer gives you this information?
As a usual process, yes, Your Honor.
And then thereafter, it goes into your files.
Yes, Your Honor.
And am I correct now in stating that after the acceptance is established, that is when you start collecting association dues?
Yes, Your Honor.
Now,
And is it presumed that that is also the time when the key to the unit was given?
For the key, sir, to turn over to Ms. Corona, I don't have an idea for that, Your Honor.
Okay. All right. Counsel?
all right. Thank you, Mr. Lim. Your Honor, no further
Any
questions.
further question,
No,
Coron?
none from you.
Your Honor, before I proceed with my cross, I believe there was a commitment yesterday to produce the originals of the documents.
Yeah. Oh, I'm sorry. I'm sorry, Your Honor. Mr. Lim, yesterday you promised to produce the originals of the documents that we identified. Do you have them with you?
Sir?
Do you have them with you, Mr. Lim?
Yes, Your Honor.
Please, please speak through the microphone so that your answers will be recorded.
Your Honor, we take a few minutes to compare this with the marked documents.
Your Honor, I'd like to manifest that I compared the originals with the documents presented yesterday, and they are faithful reproductions, Your Honor.
They're identical.
Yes, Your Honor.
All right.
Your Honor, we still have no cross-examination questions. We'd just like to request the marking of one of the exhibits as our own exhibit. This would be Exhibit 196 for the defense, which is the personal letter of Cristina Corona. We'd like to mark it, Your Honor, as our own exhibit, which would be Exhibit 11Cs, Your Honor.
Mark it accordingly for the prosecution. Any other question, Mr. Counsel?
Just one more manifestation, Your Honor. We'd like to cause the sub-marking of two phrases in this letter. One is in the penultimate paragraph of the letter. It says, I have not earned any income from this investment as our exhibit 11C-1. And in the last paragraph, I am losing money from this investment as our 11C-2, Your Honor.
Mark it accordingly.
With that, Your Honor, I have no further questions.
Okay.
Mr. President, may I also adopt the sub-markings for the defense as 196A and 196B?
All right.
Thank you.
Mark the sub-marking of the prosecution as stated by the defense as for purposes of identification as their exhibits.
Your Honor. Your Honor.
Any other question?
Before the witness is discharged, we'd just like to manifest that Senator Osmeña was requesting yesterday for how the payment was made on this particular unit. We'd like to manifest, Your Honor, that we filed a 3-page compliance detailing the details of the payments, Your Honor.
Who made the...
It was requested by Senator Osmeña.
The prosecution?
Yes, Your Honor.
We're a bit surprised, Your Honor, but I think we have a witness who will testify to the payment, the purchase, circumstances of the purchase, Your Honor.
So what's the pleasure of the prosecution?
Just manifesting for the record that we complied with the request, Your Honor.
All right. The gentleman from Cebu?
Thank you, Mr. President. Actually, the documents had been submitted a couple of weeks ago, and we would like to ask the prosecution just to clarify the difference between the contract to sell, which is dated January 20, 2004, and the Annex C, which covers the purchase price and manner of payment, which are dated January 29, 2003, or a year earlier, and shows a schedule of payment, schedule of payments to be 25,000 pesos on January 29, 2003, down payment of 543,181.82 pesos on March 28, 2003. Then the installment schedule covers first installment 1,113,033 pesos and 18 centavos on April 28, 2003. The second payment being 1,728,270 pesos and 23 centavos on October 10, 2003, and the last payment amounting to 179,446 pesos and 59 centavos, and it is marked here upon advice. So the total matches the price for the condominium, which is 3,588,931 pesos and 82 centavos. I still can't get the dates right, because while the manner of payment schedule in Annex C shows that the second payment was already, the bulk of the payments had already been made as of October 10, 2003. The contract to sell is dated January 20, 2004.
In other words, the property was fully paid in 2003.
Just about, Mr. President, based on Annex C.
If I may, Your Honor, answer, because I was the one who presented the witness from Columns,
yes.
Ms. Neresa Josef. Actually, Your Honor, what happened was initially Mrs. Corona bought a studio unit, Your Honor, in 2003. and then she applied for an upgrade of the unit to a one-bedroom unit, Your Honor. And so when it was finalized, the upgrade, it was already, I understand, in 2000, when the contract to sell was already executed, Your Honor, in March of 2004. So she started paying the studio unit, Your Honor, in 2003. And in January 2004, the contract to sell was executed.
Your Honor, while I appreciate, with the permission of kind counsel, while I appreciate the efforts to assist the court, I think perhaps that reference should be made to the record of the testimony of Ms. Joseph, was that? Perhaps that might give us a more accurate account of what was said in court, Your Honor.
Was your statement into the record covered by the answers of the witness you presented?
No, Your Honor, we did not delve into that matter already during her presentation, Your Honor.
Anyway, you take note of that.
The contract to sell, which was submitted, is dated January 20, 2004. And now you're talking about another contract to sell that was signed on March 2004.
No, Your Honor, I correct myself, Your Honor. It is this January 2004. Only one, the same, Your Honor. Only one contract to sell dated January 20, 2004.
But this is the penthouse unit that they eventually upgraded to.
Not penthouse, Your Honor. I think this is only one-bedroom unit with parking lot, Your Honor.
What was the number of the unit? Just remind
31B, Your Honor.
31, D as in David?
Is in boy, Your Honor.
B as in boy.
Yes, Your Honor.
One bedroom. Now, would the price be the same?
It was not, Your Honor. Per my interview with the witness before, there was the purchase price is not the same.
I'm sorry, Your Honor. I'm sorry. But
excuse me, please do not interrupt when the judge is asking questions. Yes, please continue.
So, the price of the studio unit, Your Honor, is lesser than the price
Just
for
give us the price of the studio unit. Give us the price of the studio unit. Is that $3,588,000?
No, Your Honor. It is less than that. I don't have the exact amount, Your Honor.
Would you get that information, please?
Yes, Your Honor.
Now, the price of the one-bedroom, Unit 31B, is $3,588,000.
Yes, Your Honor. We confirm that.
But that seems to correspond exactly with Annex C. So, was the $3,588,000 fully paid when the contract to sell was signed?
When the contract to sell was signed, it was not yet fully paid, Your Honor, because payments were subsequently made, and our official receipts that were testified to and marked into evidence would show that full payment was made only sometime in 2004, Your Honor.
In 2004?
March 2004, Your Honor.
So the $3,588,931 pesos and 82 centavos was fully paid in 2004.
Yes, Your Honor.
And, well, it never appeared on the asset side of Justice Corona, the respondent.
Yes, Your Honor. It never appeared for the payments of 2003. There was no entry as to the payments that were made, as well as to the payments that were made in 2004.
In 2005, did the cash payment of $3.5 million appear?
No, Your Honor.
In a sal of 2006, did the 3.5 million pesos appear?
Not also, Your Honor.
In 2007, did the 3.5 million appear?
No, Your Honor.
In 2008, did the 3.5 million appear?
No, Your Honor.
In 2009?
No, Your Honor.
So it finally appeared in 2010?
Yes, Your Honor.
Now, in double entry accounting, asset equals liabilities plus net worth. In fact, the Constitution is really based on the principles of double entry accounting. So therefore, if you take something out of your asset side, you have to replace it with another asset or with a liability.
Yes,
now, in this particular case, how did the respondent book an asset in the amount of 3.5 million? Is there anywhere in his sal that reflected that?
Based on the evidence that we have presented, Your Honor, for the SAL-N for the years 2003 to 2009, there were no entries made by the respondent, Your Honor.
And lo and behold, it appears in 2010.
Yes, Your Honor. And our position is that, Your Honor, even under accounting rules, an entry should have been made when payments were made. And the entry should have been an investment in real property. Or it may be even an other asset, Your Honor, but no entries were made during the
Or
years.
if there was an objection or a question, maybe an accounts receivable from Ayala Land or Alveo Land.
I agree, Your Honor. That is correct.
Thank you very much,
Thank you.
Mr. President.
All right. Counsel?
Mr. President, I would like to thank counsel for his testimony. Anyway, yesterday, Mr. President, you mentioned...
I'd like to object to that, Your Honor.
Withdrawn, Your Honor, withdrawn.
Avoid this.
May we request that that be stricken out, Your Honor, from the record?
I withdraw. My apologies, Your Honor.
Strike it out.
Thank you, Your Honor.
That was a narration of the lawyer based on his recollection of the facts.
I see now, Your Honor.
Not under oath anyway. So.
Mr. President, yesterday you asked me if this was to be treated as an asset. Oh, by the way, may we ask that Mr. Lim be discharged, Your Honor?
The witness is discharged.
Thank you, Your Honor.
Mr. Lim, you can go.
Oh, I'm sorry.
President, before we discharge the witness, may we recognize Senator Miriam Defensor Santiago?
All right. You stay on the witness stand because the lady senator from Iloilo wishes to ask a question.
Thank you. I would like to raise a question not only with this witness but also with both counsel. Mr. Witness, what is the provision of the master deed for the Columns condominium units with respect to the transfer of ownership?
For that, Your Honor, I don't have an idea.
You don't know when ownership is transferred?
For the ownership, ma'am, I don't have an idea. But for the acceptance of unit, yes, Your Honor.
All right. What is the provision of the master deed on the acceptance of unit?
Once the unit owner accept the unit, Your Honor, that's the only time that we will charge the association dues.
Under the language of the master deed, what is the meaning of accept? Do you have any idea?
That's the time, Your Honor, that the unit owner really accepted the unit.
Think again. What do you mean by accept? He accepted verbally? He accepted physically? He accepted in writing? What is the meaning of accept?
Based on my observation, Your Honor.
Your observation?
Yes, Your Honor, that there is a form on there, but that is already for the developer side, Your Honor.
Obviously, you're not very familiar with the legal aspects of the transfer of ownership over the condominium unit.
Yes, Your Honor.
Yes. Now, our issue here is, when should the condominium unit in the columns have been declared in the son of the defendant? That is our issue here. To be able to answer that issue, we have to know, when did he become the owner? Now, there are two contending sides and they have different positions. According to the prosecution, the defendant became owner when the certificate of title was issued to him. At that point, apparently, your corporation took the position that the unit was deemed accepted. Is that the language you use?
For the corporation, Your Honor, when I present the master release, it was stated that August 2009, Your Honor, that the unit accepted.
Is deemed accepted when the transfer certificate of title is transferred to the buyer. Is that your practice there in your corporation?
It was accepted, Your Honor. Accepted.
Toto, there are so many methods of acceptance in law. So, what I'm saying is, under your master deed, apparently your corporation has laid down the rule that once the transfer certificate of title has been issued to the owner and accepted by him, then he's deemed to have accepted the condominium unit. You don't need to, that is not a question, but that is apparently the position of your corporation. But on the other hand, the position of the defense is that ownership was not transferred upon acceptance of the transfer certificate of title, but was transferred only when the buyer took full possession. So there are two contradictory views of when ownership was transferred, and therefore also two contradictory views on when the property should have been declared in the SAL. What here? Transfer of title was made in 2004, but apparently declaration was made only in 2009. That is our issue today. Now, I'm going to raise this question with the prosecuting counsel. Counsel, in view of this issue, I will quote to you a decision of the Philippine Supreme Court in Cebu, Winland v. Ong Xiao, which was promulgated in 2009. In effect, in this case, the Supreme Court held that symbolic or presumptive delivery, which seems to have taken place and which seems to be the anchor for the argumentation of the prosecution. Apparently, just to summarize, prosecution takes the position that once transfer certificate of title was accepted by the buyer, that was presumptive or that was symbolic delivery. And since delivery has already been accomplished, then he was the owner as of that date. That is your position. Isn't that so?
Yes, Your Honor. And that
Yes.
is also provided for in the contract to sell, Your Honor,
All
of the
right.
particular unit.
Okay. But in the case of Cebu Winland, which was promulgated in 2009 by the Supreme Court, the court held that symbolic or presumptive delivery by the execution of public instrument, meaning to say the transfer certificate of title, and here I will emphasize what the court said, can be negated by the failure of the vendee to take actual possession of the land sold. What do you say, counsel?
Your
to that
Honor, we have
passage
cited,
in this case?
we have submitted to the court a memorandum regarding this issue, and we also cited, Your Honor, the case of Marcela versus Court of Appeals.
What case
It
was
was-
that? When was that case promulgated?
It was decided, Your Honor, in March 27 and 2007.
That was 2007. This is
Yes, Your Honor.
2009.
And the facts of the case, Your Honor.
No, excuse me. Let's stay with this particular point. You are citing to the court a 2007 case. The court is citing to you a 2009 case and is asking you to comment on this provision from the Supreme Court case. We are familiar with the rule that the latest case controls.
We have also cited a 2010 decision, Your Honor.
All right. What case was that?
In the case of Raimundo S. De Leon versus Benita T. Ong, Supreme Court said, Your Honor, that under Article 1498 of the Civil Code, the execution of a notarized deed of sale is equivalent to the delivery of the thing sold.
That is a general rule, isn't
Yes,
that so? So you're just citing a general rule. Here in Winland, Supreme Court is citing a specific rule, and you know that specific prevails over general. Now, you're citing this 2010 case. Let me ask you this question. Did it involve a condominium unit? If you are not sure, you may say so.
I am not sure, Your Honor.
All right. Now, in this Cebu Winland, on which I rely very strongly because it is the latest case, I have to quote extensively from the Supreme Court. I'm quoting now. Article 1497 of the Civil Code contemplates what is known as real or actual delivery when the thing is sold in the control and possession of the vendee. On the other hand, Article 1498 refers to symbolic delivery by the execution of a public instrument. It should be noted, however, that Article 1498 does not say that the execution of the deed provides a conclusive presumption of the delivery of possession. It confines itself to providing that the execution is equivalent to delivery, which means that the presumption can be rebutted by means of clear and convincing evidence. Now, my question to you is, since there is no conclusive presumption, you're only relying on a preliminary presumption that can be overturned by clear and convincing evidence. Isn't that so?
Yes, Your Honor.
Yes, that is your position. I don't think I have... well, let me just ask, for asking sake, the defense counsel. Counsel, what is your position? Did Chief Justice actually accept the unit?
Your Honor, may I draw your attention to paragraph 7.2 of the contract to sell. Specifically, the second half of the paragraph, I will dispense with reading the first part, but the second half which says, if rectifications or adjustments are made in the unit, the seller shall, upon completion of such works, notify the purchaser of the readiness of the unit for final inspection, and the purchaser shall have 15 calendar days from receipt of such notice of final inspection to inspect the unit together with the seller for the purpose of determining whether the necessary rectifications or adjustments requested by the purchaser in connection with the first inspection have been made. In other words, Your Honor, there is a process by which acceptance must be conducted. If there are issues raised, there is a process of consultation and verification in terms of the works being done, in terms of the gripes of the purchaser, before the acceptance is made. Now, we are all familiar with the concept of a deemed acceptance. But when we speak of a deemed acceptance, that is merely a declaration of the seller. It is not perforce a voluntary recognition of the buyer that the unit has been received in good order. That is the issue in this case, Your Honor.
You're raising the argument that the phrase deemed acceptance is unilateral on the part of the condominium seller.
Precisely, Your Honor, because a deemed acceptance indicates that there has been no acceptance by the buyer.
Counsel for the prosecution?
Your Honor, our answer to that is the applicable rule, Your Honor, is 7.3 of the contract to sell, which comes later than 7.2, which is read by esteemed counsel of the defense, Your Honor. And if I may be allowed, Your Honor, 7.3 states, the seller shall be deemed to have delivered the unit, and the purchaser shall be deemed to have accepted the unit upon the earlier in any of the following dates, Your Honor. And there are three. The date of final inspection, or if the purchaser fails to inspect the unit within 15 calendar days from receipt of the final notice of inspection. Letter B, the date of possession by the purchaser of the unit. Letter C, the date of execution by the purchaser of the acceptance form. And letter D, and this is where we are relying, Your Honor, is the date of execution of the deed of absolute sale. So when the deed of absolute sale was executed, Your Honor, the prosecution, is of the position that delivery was made. And in the case that I cited, Your Honor, a while ago in Marcella versus Court of Appeals, Supreme Court said that it is of no legal consequence that petitioner did not take actual possession or occupation of the disputed property after the execution of the deed of sale in her favor, because she was already able to perfect and complete her ownership of and title over the subject property. So that is the prosecution's position, Your Honor, that upon execution of the deed of absolute sale, possession was transferred, and according to the Supreme Court, Your Honor, in Marcella versus Court of Appeals, it was of no legal consequence that the petitioner did not take actual possession. And that is our position also in this case,
Your Honor, just very briefly, if I may. I filed a memorandum on February 15th regarding the transfer of ownership, and we cited precisely Cebu Winland, where the Supreme Court held that symbolic delivery by the execution of a public instrument can be negated by the failure of the vendee to take actual possession. Now, good counsel has cited the execution of the absolute deed of sale, and that would have been sometime in 2004. It was, however, at that time, Your Honor, impossible to take actual possession because, as pointed out by Senator Osmeña yesterday, they were just buying space. The condominium did not yet exist, Your Honor. It came into existence in 2006, which is the only point in time, realistically, that any intelligent acceptance of the goods can be made.
Well, gentlemen, you of course realize that the filing of the SAN is governed by the implementing rules and regulations of the Civil Service Commission. Have any of you gentlemen taken the trouble to inquire from the CSC when should ownership be transferred or deemed to have been transferred with respect to a condominium unit?
I'm afraid, Your Honor, that our inquiry into the matter is inconclusive. I am guided, however, by your statements yesterday. that we should be first have been motivated by honesty. As pointed out by Senator Lacson, the Chief Justice honestly declared this condominium unit in 2010 as testified by Mr. Lim after it was accepted in 2009 by Mrs. Corona. And Mr. Lim further testified that the acceptance was information given to him by the builder or the seller. So we consider that as an admission on the part of the condominium builder or seller that the transfer, the complete transfer of ownership and the free, intelligent, and voluntary acceptance of possession occurred on August 12, 2009, regardless of the provisions on deemed acceptance and the issuance of title in 2004.
Your Honor, for the part of the prosecution, our inquiry with the Civil Service Commission, they informed us, Your Honor, that the SALN form itself, as well as the provision of the Constitution, the Anti-Graft and Corrupt Practices Act, as well as Republic Act 6713, clearly states that whenever an asset, Your Honor, is acquired, it must be stated. And as duly noted by the presiding officer yesterday, Your Honor, when payments were made in 2003 and in 2004 for this particular unit, an asset should have been declared by the respondent, Your Honor, because asset it has an accepted meaning, Your Honor, and no quibbling on the meaning of asset should be debated upon, Your Honor. An asset, when you take out the cash from your pocket, then you get an asset. And this is what we are trying to point out. Acceptance of the unit, Your Honor, is of no moment because in 2003 as well as in 2004, an asset was acquired by the respondent already.
Your Honor, just very briefly, supposing the condominium had never come to be, would that 3-point-something million still be an asset? It would have become a liability.
It is, Your Honor.
If that condominium unit never came to existence and no delivery was had, it could not possibly have become an asset.
Not a liability, it would be a receivable.
Receivable.
Mr. President.
Well,
Mr. President.
Yes.
Gentlemen, may I still...
The gentleman from Cebu.
May I
have
have...
the floor.
No, I was just going to ask
I
the
thought
permission.
it was the
With the
lawyer's
permission of the gentle
I can
lady
give the
from
floor to Senator
Iloilo.
Osmeña.
Thank you, Madam Senator. I think the Senate President has a better understanding than most of us do of the concept of assets and liability. An asset can be cash, it can be a receivable, it can be a property. And as far as we're concerned, we don't really care if the condominium existed or not. It had to be booked in 2003 and 2004 as an asset, and if the unit had not been delivered, it should have been booked maybe as a accounts receivable from Ayala Land. If the unit was never delivered, even in 2010, that 3.5 million should still have appeared in his asset side. Otherwise, we have a David Copperfield thing. Now you see it, now you don't. Obviously, there was 3.5 million taken out of the asset side of the SALN of Justice Corona and given and paid to Ayala Land. So ano po nangyari doon? Hindi naman nag-appear in 2003, 2004, 2005, 2006. Then all of a sudden, it appears as a condominium in 2010. The condominium is irrelevant. The value must appear. That's what we're saying. Thank you, Mr. President.
Mr. President, I stand corrected. If the condominium had not appeared, that is right. It would still be a receivable. That is right.
One more question for the prosecutor and then I am done. Mr. Prosecutor, are you familiar with the word tradition in the law of sales?
Yes, Your Honor.
What does it mean?
Your Honor, tradition means that there are other forms of delivery rather than actual delivery of the property, Your Honor.
Are you sure that is the meaning of tradition?
That is as my recollection would serve me, Your Honor.
Maybe you need some multivitamins for neurons in your brain because that is not the meaning of tradition. Tradition comes from the Latin word which means to, like for example, to translate. That is a relative of the word tradition, meaning to say, to convey, to give manually. That is quoted by Manresa, who is the favorite basis of all our civil code writers. And Manresa insists that tradition is part of the transfer of ownership. That is what he says. He is, of course, the father of the civil code, at least as known in our country. And according to him, ownership does not pass by mere stipulation, but only by tradition. He says, the delivery of a thing signifies that title has been passed from the seller to the buyer. So my question to you is, has there been tradition in the sense used by Manresa and our other civil code authors like Tolentino, etc.?
Yes, Your Honor. We believe so, Your Honor. By execution of the deed of absolute sale, Your Honor.
All right. I'm very satisfied with the answers of both counsel. Thank you, Mr. President.
Thank you, Your Honor.
Counsel,
Senator Drilon, Mr. President.
gentleman from Iloilo.
Yeah, just a few questions on the witness, Mr. President. Mr. Lim, did I hear you correctly in response to the questions of Senator Defensor Santiago that the only time when you charge association dues is when there is acceptance?
Yes, Your Honor.
All right. And therefore, acceptance has nothing to do with the date when the deed of sale was signed.
Yes, Your Honor.
It has nothing to, acceptance has nothing to do when the date, with the actual date of registration of the deed of sale was done.
Yes, Your Honor.
In fact, acceptance has nothing to do when, by law, the ownership was transferred. Is that correct?
Yes, Your Honor.
Now, in fact, payment of union dues can be delayed. The payment of condominium dues can be delayed by the simple refusal of the owner to accept the unit. It can be delayed.
There is a possibility, Your Honor.
Yes, there is a possibility. And in fact, in this particular, well, in your position, you have no access as to when the titles were issued.
Yes, Your Honor.
Nor when the titles were registered.
Yes, Your Honor.
That's all for the witness, Your Honor.
Actually, I think we are all confused about this whole thing, but actually it's simple as far as this chair is concerned. We are talking of asset. The asset originally was how much? 3-point-something million. That was transformed into a concrete asset known as condominium. But still, from the beginning of time of this contractual relationship, there was an asset. Only that it passes from cash to a concrete thing known as a condo unit. The condo unit came into existence when it was actually constructed. But all along, there was an asset that must be reflected in one's SAL-N, whether it is in the form of a condo with a number placed opposite it, or a currency account with a number placed alongside with it. Isn't it? The consideration for the condo was an asset that ought to be reflected in the SAL-N of the buyer. So, whether we talk of pesos and centavos or unit, there was an asset from the very beginning. Okay?
We agree, Your Honor.
All right. Counsel, next.
Yeah, Your Honor, may we request that Mr. Lim be discharged?
The witness is discharged.
Yeah.
Thank you, Your Honor.
We would like a minute to call our next witness, Your Honor.
Proceed.
Thank you. Carmina.
1 minute suspension.
Thank you, Your Honor.
Counsel,
Your Honor, we call to the witness stand. May we proceed, Your Honor?
yes, proceed.
May it please the court. We call to the witness stand Ms. Carmina Cruz, the Customer Relations Officer of the developer of the Columns Condominium, Alveo. Is that correct?
Yes. Good afternoon, Your Honor.
May we request that she be placed under oath?
The Secretary will please put the witness under
Please stand up and write. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding? So help you God.
Proceed.
With your permission, Your Honor. Ms. Cruz, good afternoon.
Good afternoon.
Yeah. Would you kindly inform the court of your personal circumstances? Meaning to say, yes, your civil status, your work, etc.
Yes, I am with I'm with Alveo Land. I'm the customer relations head for Alveo Land, and yes, I'm single. Yeah.
We're putting the gentleman public on notice.
There.
Kindly fix your microphone so that your words will be
Is this okay, Your Honor?
will be recorded properly.
Speak louder.
All right. Yes.
Ms. Cruz, can you tell us how long you have been with Alveo Land?
I have been with Alveo Land for 9 years. It was Community Innovations before, and now it is Alveo Land.
All right. What is the business of Alveo Land?
It is a real estate business.
All right. What are some of the projects of Alveo Land?
Your Honor, please, I hate to interrupt, but the purpose has not been laid, Your Honor.
Oh, I'm sorry.
Thank you.
Your Honor, forgive me. We are presenting this witness to establish that the acceptance of the columns unit purchased by Mrs. Cristina Corona did not occur until August 12, 2009, because there were defects or issues raised with Alveo Land that precluded the free and voluntary acceptance of the
You're
unit.
proving this fact from this witness.
Yes, Your Honor.
All right.
She represents the developer with whom those issues were raised.
All right. Please, has she recorded her personal circumstances?
I will ask her to do it again,
All
Your
right.
Honor.
Proceed.
Ms. Cruz, in a more forceful voice, can you please tell us your personal circumstances?
Okay, I am with Alveo Land. I have been with Alveo Land for 9 years. It was previously Community Innovations. And yes, again, I am single. I guess. And I'm basically, I think that's about it. Is that okay?
Yes, that's fine, Ms. Cruz, unless you want to tell us about your sports. But can you please tell us what is the nature of the business of Alveo Land?
Yes, Alveo Land is doing the real estate business.
All right. What are some of the projects of Alveo Land?
Our projects were Verdana Homes, Bacoor, the Columns, to Surrendra, and of course, the Derato, sorry. Yeah.
Try
to name a few.
Try to speak a little slower.
Yes.
All right. Can you please tell me what your job is? Customer relations specialist, is that right?
I'm the customer relations head.
Head, all right.
Yes.
What
for
does
Alveo
that
Land.
mean in terms of functions?
Basically, we assist customers. Our main focus is on turnovers to the customers of their properties.
Now, when you say you assist customers, what do you mean?
We notify the customer on when turnovers will be done, and then we invite them. We have representatives to assist them and do the delivery acceptance of the unit.
What do you mean you invite them? You invite them to what?
To come to the property, inspect the property, and do the acceptance.
To inspect and accept the property, is that correct?
Yes, that's
Yes.
correct.
Now, this is your function. You oversee this function, or do you do it personally?
I just oversee.
You oversee, and every process of inspection and acceptance, I take it, will somehow find its way to you. Am I correct?
Yes, there's some monitoring being done.
All right. Now, when we say that you invite them to accept or to inspect, I'm sorry, let us go first to inspection. When you say you invite them to inspect, may we know when this happens? When do you invite someone to inspect?
We invite when there's completion of the building, we get the list of customers who are fully paid, and then we notify the customer about the availability of the unit, and then invite them for inspection.
Now, you mentioned that one of your projects was the columns, am I correct?
Yes, that's correct.
Yes. Can you tell us if you know when was the building completed?
From my recollection, it is around 2006. I'm not just sure of the exact date.
Were you already employed by the condo developer
Yes, Your Honor.
when that building was completed?
Yes, Your Honor. I was
Oh.
already employed.
So, am I correct then in stating, based on what you have said, that you invite persons to inspect after the building is completed and if they have fully paid? Am I correct then in stating that you started to invite unit owners to inspect only after 2006?
On that year, 2006.
On that
yeah.
year, all right. And you said that the invitation extends only to those who are fully paid, is that correct?
Yes.
All right. Now, would you happen to know Mrs. Cristina Corona as one of the unit owners of the columns?
Yes, I recall her. In one
Yes.
of the
Now,
ones.
would you recall Miss Cruz, right?
Miss Cruz.
Yes. Would you recall if you extended an invitation to inspect to Mrs. Corona?
As a matter of procedure, yes, we should have.
Yes.
We should have.
But you're not sure?
I have to look into our records, the exact letter. I wasn't able to because I was summoned here today. Also today.
Was Mrs. Corona's unit fully paid in 2006?
I am not too sure as well, Your Honor.
Now,
Proceed, Counsel.
thank you, Your Honor. Do you have correspondence with Mrs. Corona? I mean, written correspondence. Have you exchanged writings, letters, notes?
Yes, there would be letters already.
You recall some?
Yes, I would. I do.
Can you give us some idea what those exchanges might contain?
What I remember clearly would be the deemed acceptance of the unit.
All right. Now, do you recall having written her a letter on the 4th of June, 2008?
Yes, I do recall that.
Your Honor, may I make of record that I am showing the witness a photocopy of a letter dated 4 June 2008, and I invite the counsel for prosecution to see the document.
Noted.
Do you confirm that this is a photocopy of your letter?
Yes, I do confirm that it was a photocopy.
We have not been shown the original, Your Honor.
Do you confirm that you wrote the original of this letter?
Yes, I do confirm.
Can you produce the original of this letter if we should require you?
Normally, the original of those letters would be to the addressee.
Can you produce any copies you might have in your office of the same?
Probably still a photocopy. Yes, I can produce.
Your Honor, and just to save us the trouble of a continuing objection, I would like to manifest that the witness confided in me that while she is aware of all these documents, she does not have the files with her. But in order not to disrupt the flow of the discussion before the court today, I have agreed to present her.
All right.
Thank you, Your Honor. Now, do you confirm, therefore, that at some point you wrote this letter to Mrs. Corona and you said in that letter, acceptance of said unit should be on or before June 7, 2008?
Yes, I am confirming that.
Yes. Then, do you also confirm that this is in reference to Unit 31B, Tower 1 of the columns?
Yes, that is for 31B Tower.
Is it your testimony, therefore, that as of 4 June 2008, the unit has not yet been accepted by Mrs. Corona?
Yes, as of June 7, 2008.
Your Honor, may I
June 4th,
request that
2008.
the letter be marked as Defense Exhibit 213?
Mark it accordingly.
And that the date be submarked as 213A.
By the way, just to clarify, in 2006, the building was completed.
In 2006, Your Honor. Yes,
Then,
the building was
when
completed.
did you notify Mrs. Corona to inspect the unit?
For all the units that have been fully paid, there would be a notice in 2006, Your Honor, but I have to check on the specific record for Mrs. Corona.
You do not remember that you notified Mrs. Corona in 2006?
Yes, Your Honor. I do not recall at this
But
point.
when you sent this letter, dated June 2008, was Mrs. Corona already notified or invited to inspect the condo unit?
Based on the content of the letter, it seems that there has been a notification previous to that letter.
No notification.
There seems to be already one.
What makes you think that there seems to be?
Because it's already, is it? Okay. It says on the letter, if I may.
Yes.
Should the unit still not be accepted by then, we shall already deem and consider the unit as having been delivered and accepted as of June 2008. So it seems already a notice, a final notice. But I have to really check on the records, Your Honor.
All right. Proceed.
Your Honor, before questions will be made,
Yes.
we would like to manifest our continuing objection, Your Honor. Not only on the
Why?
photocopy that is being testified to by the witness, Your Honor, but also on the basis of irrelevance of these questions, Your Honor, to prove the actual delivery. As we have already made clear, Your Honor, for the prosecution, what matters was that the cost paid was made in 2003 and 2004, and they were never reflected in the SALN for 2003 and 2004 and beyond, Your Honor. So acceptance or actual acceptance is irrelevant insofar as
Your Honor.
the prosecution is concerned, Your Honor.
But anyway, the court takes note of all of these facts and take them into account in the assessment of the evidence.
Thank you.
The understanding of the presiding officers that they are dealing with the actual reflection of the condominium unit, the concrete representation of the cash payment to Ayala, to the developer for that unit. So let it be. The witness may answer.
After sending her, if I may proceed, Your
By the
Honor.
way, Ms. Cruz,
Yes, Your Honor.
is this document produced from a document in your possession?
Sir, if it's a reference to the original, there was an original.
That is a photocopy of the original?
Yes, normally we photocopy the original and the original is sent to the addressee, the owner.
And this photocopy was in your possession?
No, sir. Not this specific one. This was not The one I brought.
Well, from what other document was this photocopy produced?
That was a copy produced by the defense, Your Honor.
From
I'm not sure. Where did we get this? Oh, from Mrs. Corona, Your Honor. I'm informed.
that's from. This is a photocopy of the original in the hands of Mrs. Corona.
Of a document that Mrs. Corona holds. I'm not sure if it is still the original, Your Honor.
All right.
But suffice it to state that the witness has identified the letter as hers.
Yeah, okay.
Thank you, Your Honor. Your Honor, Madam Witness, after you wrote her on the 4th of June, 2008, do you recall if Mrs. Corona replied to you?
I'm not very specific on I do not recall the specific response.
Do you recall if there was any response?
Yes, I do. Yes, I do.
All right. Your Honor, at this juncture, I would like...
What do you mean, yes, I do? You recall
I do recall a certain...
do you recall that there was a response?
Yes, I do recall that there was a response.
Okay. Thank you, Your Honor. At this juncture, I would like to present for the examination of the witness Defense Exhibit number 46, previously marked. This is a letter dated June 7. Do you recognize this letter, Ms. Cruz?
Yes, I do recognize that letter.
Would you be so kind to inform the court, just for purposes of the record, whom this letter is from?
It was from Mrs. Tina Corona.
And do you recognize this as the response to your letter of June 4, 2008?
Yes, yes.
Now, you said earlier that in your June 4 letter, you informed her that the unit must be accepted by the 7th of June. Is that correct?
Yes, yes.
Now, in this letter of 7 June 2008, did Mrs. Corona accept the unit?
On June 7, 2008, no, there was no acceptance yet of the unit.
Would you like to read the text for the Honorable Court, just so that they will be informed what the letter says?
Dear Carmina, this is Mrs. Corona. I have been following up with your office, with Charlene Pangilinan and Eds Fajardo about the originals of our tax declaration and RPT receipt for 2008, open close parenthesis, prorated, so I can settle my payables and accept my unit, Columns Tower 1, Unit 31B. Please give me an update ASAP. Thank you, Mrs. Tina Corona.
As this has already been marked, Your Honor, we shall no longer be marking the same. Do you recall, Ms. Cruz, after that letter, whether or not Mrs. Corona replied to you? I mean, you replied to her, I'm sorry. After Mrs. Corona's letter of June 7, did you reply to her?
Yes, I do recall an exchange of letters too.
I'm showing the witness exhibit number 45 of the defense. Do you recognize this document?
Yes, I do recognize this document.
Who wrote this document, if you know?
Yes, it was me. It was from Carmina A. Cruz. That's me.
Do you recall what this document was about, Madam Witness? Why did you write her back?
It refers to the request of Mrs. Corona on the tax declaration and real property tax receipts and the acceptance of the unit for 31B, Tower 1, the Columns Ayala Avenue.
What did you tell her? Read the text if you don't mind, in order to put it on record and so that everyone paying attention might be enlightened as to what we are discussing.
All right. It just states that regarding your request for your tax declaration, RPT receipts, we are happy to advise that these are already available. Enclosed is a copy of the tax declaration for your unit under your name, of which the original may only be released upon settlement of the real property tax from June 7, 2008 until December 2008, amounting to 8,167.50 cents. And however, we seek your understanding that this should not hinder you from accepting your unit, As stated in your previous letter to you, the computation of your real property tax will be based upon the date of your acceptance of your unit, which should be on or before June 7, 2008. Should you fail to personally accept or send a representative to accept the unit, we will nevertheless deem the unit accepted and delivered on June 7, 2008.
In other words, am I correct in stating that there was a balance due from Mrs. Corona at that point in time?
Yes.
What was the balance for, if you remember?
For the real property tax.
Who paid for the real property tax? Up to that, this letter was dated 11 June 2008, right?
Yes.
Who paid for the real property tax up to that point in time?
The basic procedure is really, before the turnover, it's the developer who pays for the real property tax.
So until 2008, the real property tax had been paid by?
The developer.
Who is the developer?
This is Alveolan.
That is your corporation.
Yes.
And so up to this point in time, you had paid the real estate property tax and you were asking her to pay you back. Is that correct?
Yes.
Had she accepted the unit at this point of time? At this point in time?
There was already notification on the deemed acceptance on or before June 7, 2008.
There was a notification on?
Deemed acceptance.
Deemed acceptance. What do you mean by a deemed acceptance, Ms. Cruz?
On the deemed acceptance, when there is no, on the previous notices, if there's any, and no proper response is provided, then there's an automatic deemed acceptance of the unit.
Who determines the occurrence of a deemed acceptance?
Based on company policy, it is determined via the seller.
Does the deemed acceptance involve any participation on the part of the buyer?
If it seems stated on the contract to sell, then normally it is exercised by the developer.
So it is an act of whom?
The developer, the seller.
So when you say there is a deemed acceptance, who makes the pronouncement of a deemed acceptance?
It's the seller.
It is the seller. Does it follow that if there is a deemed acceptance, that the buyer has accepted the unit?
Upon declaration of the deemed acceptance, yes. It is an understanding of the developer that the unit has been accepted by.
Can you please show me if there has been any indication of the acceptance of your deemed acceptance?
Are you impeaching?
No, Your Honor. There is another document that will establish the truth of the matter.
Precisely. The tendency of your questions.
Yes, Your Honor. Go ahead, ma'am.
Trying to confront your witness with an impeaching evidence.
Sorry, Your Honor. The letter is from her also.
Then present the letter.
All right, I'm showing you a letter dated 3 September 2008. Do you recognize this letter?
Yes, I do recognize this.
Can you tell us what this letter is?
May I? On September 3, 2008, it refers to the deemed acceptance of the unit of your unit 31B Tower 3, the columns Ayala Avenue, and its tax declaration. As you had been advised by our technical representative, Denise Aniceto, the rectifications to your unit have already been completed. The keys of the unit may be claimed from Mr. Aniceto.
So that was dated 2008?
Yes.
And where were the keys?
The keys at that time was with the office, with Mr. Aniceto.
And up to this point, what kind of acceptance had been made on the unit, if any?
It's a deemed acceptance.
Is a deemed acceptance. Was there any acceptance on the part of Mrs. Corona?
Already answered.
Thank you, Your Honor. May we request that the document be marked as Defense Exhibit 214, that the date be marked as 214A. Yeah. Now, Madam Witness, it seems that this letter of yours, now marked as Exhibit 214, has certain attachments. Do you recognize these attachments?
Yes, I do recognize the attachments.
Can you tell us what these attachments are?
It is the information given to Mrs. Corona.
Will you kindly fix your microphone?
Okay. Yes. This letter signifies that it was informing Mrs. Corona of the tax declaration under her name for the subject property, which is 31B Tower 1, the columns Ayala Avenue. And then it is from the Division Manager of Sales Support for Ayala Land Group, Pichi Pasana. And attachments were the tax declarations under the name of Mrs. Corona, Christina R. Corona, married to Renato C. Corona.
What is this attachment, the third attachment?
There's a real property tax receipt attached to it also.
And can you tell us more about the real property tax receipt? Who paid for the taxes in 2008?
It says in the document that the declared owner and the payee is Community Innovations Inc., Makati City.
And that is whose company?
That is the developer.
That is the company you work for?
Yes.
Your Honor, may we request that the attachments be marked as 214B, C, D, and the name Community Innovations as 214E, and the statement and the last two documents as 214F, G, and H.
Mark them accordingly.
Your Honor, the defense counsel a while ago confirmed with me, Your Honor, that these are mere photocopies, and they will present the original.
That is right, Your Honor. We will do our best to find the originals and present
So
them.
may we just request that the marking be provisional, Your Honor?
Why don't you establish the lady basis for the secondary evidence so that we will not be tarried by all of these requests for originals?
Yes, Your Honor. Now, Madam Witness, I refer you to Exhibit 214A, B, C, 214C. Would you know who caused the preparation of this declaration of real property?
There would be a division for that from the developer.
So this was prepared by, or caused to be prepared by?
Cost to be prepared by a division from our department, from the developer. Yes.
From your, all right. And it says clearly that the owner here would be?
Christina R. Corona.
All right. Now, in the next document attached to your letter, who caused the payment of the real estate tax?
As a basic procedure, upon turnover, normally the developer advances the payments. So it's a division in the developer side advances the payment for the owners.
And the payment was made in whose name?
Under this tax receipt, it was under Community Innovations, Inc.
Now, Ms. Cruz, do you recall after this letter to Mrs. Corona if she accepted the unit after September 2008?
The letter was a deemed acceptance, and after that, we had no communications with Mrs. Corona.
All right.
Just a minute. What are those copies?
Yes, Your Honor.
Exact copies of originals?
From what I recall, sir, they are exact copies. But I have to check also the files.
They are exact copies of some originals.
We just have copies on file of the letters, Your Honor.
The originals, who has possession of the originals of those documents?
We usually release the originals to the owners or to the addressee. That means Mrs. Corona.
To Mrs. Corona?
Yes.
So they're in the possession of Mrs. Corona?
Yes.
So these are faithful copies of those originals in the hands of Mrs. Corona?
Yes, Your Honor.
So these are secondary documents on all fours, identical with the documents with Mrs. Corona?
From what I recall, but I can check what we also have on record.
All right. These are secondary evidence.
Yes, Your Honor.
That's the way how to lay down the premise
yes, Your
in
Honor.
the introduction of secondary evidence.
Thank you very much, Your Honor. So, going back, thank you. Did you receive an acceptance from Mrs. Corona?
Objection, Your Honor. Already answered,
All right.
Your Honor.
When you said deemed acceptance, who made the deemed acceptance?
Or your objection, Your Honor. She is arguing with the witness, Your Honor.
Already answered.
Yes, Your Honor.
Don't be repetitive.
Madam Witness, did you communicate the acceptance to the condominium corporation?
I don't recall of me personally communicating.
Are you familiar with this procedure?
Normally, it is through a list provided to them.
And who provides that list? Would you know?
On a basic procedure or company policy, it's really the developer also to notify the condominium corporation.
You mentioned earlier that you were responsible for the inspection and acceptance.
Yes.
Right. So when you receive the acceptance, how is it transmitted to the condominium corporation for the collection of dues?
There is a monitoring that is provided to
Would
them.
you be familiar with the information transmitted to the condominium corporation?
At that time, I don't recall at that period.
Would you be in a position to obtain the records?
Yes, I would.
You would.
Is there any issue with respect to that particular point?
Your Honor, it was testified by the other witness that the acceptance was given on a specific date. But this witness does not have the documents, the source documents, which were transmitted to the condominium corporation regarding the date of acceptance by the purchaser. That is the only link left, Your Honor. There are also communications between...
I do not know the purpose of these questions or the evidence being elicited by the counsel, but you go ahead and ask your question.
Your Honor, okay. Now, your letter of June 4 makes reference to a re-inspection. Is that correct?
I have to. Can I see the letter again? Is it the one? Yes. Mm-hmm.
Then I take it to mean there was a previous inspection.
Yes.
Do you have any documentation of the previous inspection?
That we have to check on our records if we have.
Can you bring any records regarding the previous inspection?
I will try to find those records.
If there is a re-inspection, what does that mean?
If there is a inspection, it means that there was a punch list or something that needs to be done previous to these letters, and then they are notified of its completion.
Yeah. What is a punch list?
A punch list is essentially what is seen on the unit that needs rectification.
I'm sorry, what do you mean?
What is seen when doing the inspection?
Yes.
When the
What do you
unit
mean,
owner,
what is seen?
when the unit owner is escorted into the unit for an inspection, if there's anything that needs to be rectified according to the unit owner's wish, then that, or taste, sometimes depending on defect.
Defect?
Also, probably defect, yeah.
So you mean a defect?
A defect or even just a dirt, something like that.
Right. So you mean if there is something wrong,
yes,
like a defect, it goes where?
into a punch list.
Into a punch
Yeah.
list. So you're telling me that there was a punch list which called for
Yes, most probably.
for
Yeah.
what? A
Re-inspection.
re-inspection. Do you have that punch list?
We have to check if it's still with us.
Can you bring the punch list if so required?
Yes, we can try to look for it at this time.
Your Honor, may we request that the witness be instructed to bring the other documents relevant to the communication
You
with the
state the
client?
documents that you want to be brought here.
Your Honor, principally all the correspondence preceding your letter of 4 June 2008, which will establish your invitation to inspect, establish the defects found, and other instances which relate to the acceptance and turnover of the unit. Are those documents within your reach?
Yes, but we have to check on where we can also.
Can you also bring the documents that relate to the information relayed to the condominium corporation?
Yes, I'll try to find out
Anyway,
where it is.
Madam Witness, when did Mrs. Corona finally accept this condo unit?
From my recollection,
If you know,
yes, Your Honor. What I only recall is the last letter of September 3, 2008, and then that it was deemed accepted in June 7, 2008.
June 7, 2008.
Yes.
She accepted it already.
It was deemed accepted, Your Honor.
No, but actual acceptance.
No, there was no actual acceptance. It was only a declaration of the deemed acceptance.
Until today, she never expressed acceptance of the unit.
That I have to check on our records.
All right.
Yes.
Your Honor, until I have the other documents, I cannot proceed. May I request that the witness be instructed to return with the documents we request?
Proceed. You may, the witness is instructed to return tomorrow afternoon at 2 o'clock during the resumption of this trial and bring all the documents requested by the counsel for the defense who put you on the witness stand. So order.
Yes, Your Honor.
You are discharged in the meantime. There's no cross. Next witness.
Your Honor, thank you very much, and may it please the court, I would like to cede the podium to co-counsel Dennis Manalo.
Yes.
Habang tinatawag.
Oh, dokumento mo.
Habang tinatawag. Matawag mo muna.
Do you have another witness?
Yes, Your Honor. We will call to the witness stand Attorney Perlita V. Ele, the clerk of court, ex-officio sheriff of the Regional Trial Court of Quezon City.
All right. Where is Miss Sele?
May we ask for 1 minute suspension for her to...
Mr. President, while we're doing that, I move that we suspend the trial for 15 minutes.
Right.
Trial suspended for 15 minutes.
Nire-request nila eh. Nire-request ng mga senador eh.
Magtanong eh.
Si Roy.
Hindi po natin tututukan yung aspetong yan dahil po yan is for the senator judges. We have laid down our position and we leave it at that. Yung pangalawang testigo po ay si Miss Cruz ng Alveoland, ang nagmamay-ari po ng columns, previously Community Innovations. Pero po maganda rito na makikita po ninyo na meron silang communication ni Mrs. Corona ukol sa mga problema na hinaharap ni Mrs. Corona sa condominium unit. At inadmit naman po ng testigo ni Miss Cruz na merong sila talagang exchange of communication. At nakita rin dito sa exchange of communication na hindi tinatanggap ni Mrs. Corona ang unit. Sinabi lamang po nila ng kumpanya that this is deemed accepted. Pero po siguro ang importanteng dokumento na dapat nating makita is yung hiningi na ni Mrs. Corona yung tax declaration sometime in 2008. At napatunayan po doon na ang tax declaration ay nananatiling nasa pangalan ng Community Innovations, ng developer. So ito po sa tingin namin ay mga importanteng ebidensya na ating dapat tandaan para ma-determine natin kung kailan talaga dapat inilagay ang kumpanyang ang property ito sa SAL-N ni Chief Justice Corona.
May dadagdag lang ako, no? Siguro yung isang kailangan din ma-highlight dito na ito yung isang sale ng pre-selling development ng apartment. Hindi ito katulad ng ordinaryong sale ng lupa. So, kung tatanungin ninyo na kung bakit yung doon naman sa pagbebenta noong lupa nga kay Demetrio Vicente dati, bakit as soon as nabenta ay wala na sa SAL-N ni Chief Justice Corona, iba ho yung issue doon. Doon, lupa lang yung binenta at as soon as mabenta ay dineliver na ho kay Mr. Demetrio Vicente na tinirahan niya na agad. Dito, yung general rule na tinatawag natin ganun na upon yung sale and delivery ay hindi kapareho pagka pre-selling ng condominium apartment. Kasi katulad dito, 2004 na-execute yung deed of sale, pero hindi pa nagagawa yung apartment noong time na yon. Natayo lamang yung columns 2006. And noong 2008, yun nga yung sinabi nga ng aming testigo, na nung panahon na yon meron pang outstanding balance from Mrs. Corona at yung mga susi doon sa apartment ay nasa kanila pa. So makikita natin dito na 2008 ni hindi pa na-deliver yung physical possession ng mismong unit kay Mrs. Corona. Hindi pa sila nakapasok at natirahan ito. So yan yung mga nakikita natin pagkakaiba dito. At meron mismong guidelines yung Alveoland kung kailan tinatawag nilang may deemed acceptance. So ito yung mga bagay na makikita natin na kung sila mismo ay nagkakaroon pa ng mga termino tulad ng deemed acceptance, ibig sabihin hindi siya katulad ng normal na purchase and sale ng mga property katulad ng land na meron kasing pagkakataon pagka pre-selling pa lang yan, kahit binili mo na yan ahead, maaaring hindi naman mabuo yung unit. Hindi mo alam kung anong circumstances ang pwede mangyari. Baka maging eventually bankrupt yung developer or magkaroon ng force majeure or kahit anong pangyayari katulad ng lindol na hindi naman matatayo yung unit. So ito yung mga issues na kailangan natin i-consider dito sa pinag-aawayan nga kung kailan dapat ba nakadeklara sa SAL-N ni Chief Justice itong columns property.
Sir, ma'am, pero yung sinasabi po ng mga senators na dapat dineclare pa rin kasi naglabas ng pera, ano po yung reaction nyo dun?
Sa amin naman kasi, yung issue dito, ang pinag-uusapan, properties nga na dineclare sa SAL-N. And in relation to columns, ang property dito, yung apartment. So, it deals with yung asset na dinedeclare mo. And para sa amin, kung ang dinedeclare mo nga yung columns property, then ang issue is kung kailan ba considered na transfer yung ownership of that property kay Chief Justice Corona or sa kanyang asawa para ma-declare na to sa SAL-N. Ngayon, yung pagbayad ng pera, I don't think yan yung dapat na punto na titignan kung kailan ilalagay sa SAL-N. Kasi isipin niyo kung ang pinambayad mo sa apartment ay utang, then is that an asset na when in fact it's a liability, 'di ba? So, yun yung mga bagay na tingin namin ay kailangan na pag-deliberate na maayos at pag-usapan ng matino dito sa impeachment because I think hindi mo pwedeng sabihin na yun in this case 2004 pa lang ay dapat nasa salin na yan kung hindi pa nagagawa yung apartment at that time at hindi pa man lang nabibigay doon sa mag-asawang Corona. So these are mga kakaibang circumstances na hindi present sa ordinary purchase and sale of a land.
Ma'am, kung Earn Reyes po, kung ay, meron po ba?
Dagdagan ko lang kung maaari lang, dagdagan ko lang, mabilis na mabilis. Tama po yung sabi ni Attorney Karen. No? Gusto ko lang ho sanang idagdag, katulad nga ho ng nasabi na rin ng aming kasamahan kanina, lahat ho ng patungkol dun sa mga entrada pa doon sa salin ni Chief Justice Corona. Ito po ay magpipresenta po kami ng mga testigo na magpapatunay at magpapaliwanag po no, kung bakit ganito ang mga entrada doon sa kanyang salin. So malinaw po yan, manggagaling po yan, yung explanation po, no, yung pagpapaliwanag, manggagaling po sa isang testigo, hindi po manggagaling sa abogado. Sapagkat gusto ko na rin klaruhin ngayon pa lang, mukhang parang nagbabago rin ho yung trial procedure natin. No? Kasi ngayon, maaari na rin ho palang tumistigo ang isang abogado. No? Kasi usually, ordinaryong trial ho, yung abogado hindi ho maaaring tumistigo yan. Pero nakita ho natin kanina, may mga katanungan na ibinato sa isang abogado at sinagot naman ng abogado yun. No? Sa amin po, sa depensa, makikita nyo po na lahat ng mga testimonya at lahat po ng aming mga ebidensya, hindi yung manggagaling sa aming mga abogado, manggagaling po yan sa aming mga testigo, sapagkat yung pong testimonya nila, pinanumpaan nila, at maaari po talaga silang tanungin dyan. So malapit na po ang explanation namin dyan.
Yung tanong ko lang po, kung hindi nga talaga na-accept ng actual yung condominium unit, bakit hindi dineklara yung pinambili ng unit?
Briefly. Kasi po ganito yan, I think yung katanungan ninyo ay tanong rin ng ibang mga senator judges. Kasi kung may salapi, meron dapat na pinambili. At yung salapi na yon ay dapat nakadeklara sa SALN. I think yun ang tinatanong ninyo, no? Kung titingnan nyo yung SALN, ay may mga detalye po yan na sinasabi na may pera. Opo, nakikita nyo yung mga pera sa particular na taon. Hindi ko lang po accurate kung 2.5, 3.5. Depende sa taon po yan, no? Nakita nyo naman yon. At makikita nyo rin po sa SALN na meron pong advances. Nakita nyo po, parang inutang na halagang 11 million. Hindi po namin pipiliting ipaliwanag ngayon yan dahil dapat testigo magpaliwanag yan. Pero po sasabihin namin, ang yung concern ninyo ay address namin, yung money in, money out. Kung may pera, ay may binili. Yung binili, ayun ay dideklara. Yun po yung gagawin namin.
Yung isa lang din na idadagdag ko doon, from a logical standpoint, kahit hindi kami pumunta into details, kung pinambili mo kasi ay, kahit sabihin mo ng utang, de paano mo siya idedeklarang asset? Kasi in that case, kahit na pinambili mo siya no up ng property, di ba? Idedeclare mo yung pinambili mo as a liability. Kasi inutang mo yun eh. So, kahit na sabihin mo hindi pa na-transfer sa'yo yung property, kaya hindi pa naka-reflect doon yung actual property na binili mo dahil hindi pa na-transfer sa'yo yung ownership, yung liability, kailangan mo na i-declare siguro yun doon sa under yung column na liability. Pero kung sinabi mong kinita na yung pera na yon na pinambili, then naka-declare yun siguro sa cash, pero kung ipinambayad mo yung part of it, then yun yung sinasabi mo babawas doon, pero dahil hindi mo pa nga nakuha yung ownership, yun yung hindi pa naka-declare yung asset, di ba? Pero kung binayad mo na siya, mawawala siya dun sa bank deposits, pero maaring meron ka namang liability, so mapupunta sa liability. Kaya hindi mo makikita yung buong halaga nung actual value ng property na binili mo. Parang ito nga yung mga bagay na ipapaliwanag as we go along. Kasi hindi nga siya simpleng math lang na sinasabi natin na kunwari 3 million yung columns and dapat may makikita kang 3 million agad na cash assets.
Di ba umutang siya sa Basa Guidote nung 2003? 11 million. Tapos
Advances na tawag.
Advances.
Oo, na nakadeklara yan.
Tapos nakadeklara ng 2004 is pares pa rin.
Tapos nababawasan kada taon.
2004 muna. 2004, parehas pa rin. But sinasabi ng the column na yung contract of sale is 2003. So dapat yung inutang niya doon, nabawasan na yon.
Hindi. Utang pa rin yun eh. Kung pinambayad niya yun doon sa columns, hindi mababawasan yung utang niya. Because yung utang niya outstanding pa rin. Ibig sabihin, yung liability niyang yun, na 11, hindi niya kinita yung perang yung kaya hindi siya cash asset. Kasi utang yan eh. So, kailangan niyang bayaran yung buong 11 million. It's a liability to you. It's not your asset. So, kung pinanggamit mo yan para bumili ng property, pero hindi mo pa nabayaran yung part of the 11 million, then it will stand as 11 million. Hindi ibig sabihin na kung pinambayad mo 3 million out of the 11 ay mababawasan na yung liability mo. Kasi hindi mo naman binayaran yung utang eh. So, buo yung 11 million pa rin.
Okay.
Okay. Okay na? May katanungan pa po? Oh. Si si Justice Cuevas, siya ay nagpapahinga and I think it's okay. Kaya lang siguro ayaw niyang madaliin na bumalik pa. Nakikita naman niya na napipresenta naman namin ng mga testigo. But of course, we want him to be here because he is our leader and he gave us guidance. So inaasahan namin na sana'y nandito na siya bukas so that he could continue to give guidance to the team. Ang tawag dito yung vertigo, binanggit nga ni Senate President. Ito yung para kang nahihilo talaga. And in fact, the Senate President suggested a medicine for him. Narinig ko rin po yun doon sa mga may vertigo. Hindi ho madali. Wala naman siyang serious na karamdaman. Kaya lang yung nahihilo, of course, that's very important for balance because he will stand up there for a number of hours. May dati na raw siyang karamdaman gano'n, bumalik lang. So, binabantayan lang yung vertigo na yun. Okay. Anong effect ng absence niya? Of course, double time kami. Of course, we have to persuade more because iba yung nandun siya. Iba yung nandun si Justice Cuevas explaining on the floor. And although, of course, sinusubukan namin punuan ang absence niya, we hope that we are able to do it. And we are able to continue on a day-to-day basis.
Sir?
Hindi naman nawalan, no? Pero kasi parang he enhances us eh. Yun nandun siya. Of course, may kanya-kanya kaming kakayanan bilang mga abogado, pero iba rin yung nandun siya. Para kang meron kang, kung sasabihin natin sa Tagalog, meron kang timon. Okay, may timon ka, kumbaga sa barko. O yung may giya ka. Ganon, okay, na tinatawag.
Sir, reaction lang po dun sa Pulse Asia survey kasi sabi ng prosecution, nagpapakita daw yon na malakas yung ebidensya laban kay Chief Justice.
Well, alam niyo po, kanya-kanya naman po tayo ng opinion. Maaari ho yan ang opinion ng prosecution. Ginagalang ho namin yan. Ngunit sa amin po, malinaw po ang posisyon ng depensa. Kami po ay nandito na ngayon sa pagkakataon na kami naman po ang dinidinig. No? Ngayon po ang aming pagkakataon na makapaglatag ng aming ebidensya, makapagpresenta ng aming mga testigo. At kami po ay buo po ang aming pananampalataya na ang ating po mga kababayan na nagmamasid ngayon ay makikita rin po nila at mauunawaan po nila kung saan po papunta ang kaso. Sapagkat kami po ay naniniwala, no, na although maaari hong sabihin na ito ay yung public perception kung tawagin ho, no? Madalas ho kami natatanong sa public perception. Kami po kasi sa bandang huli, umaasa po kami na ang mga senator judges, sila po ang inatasan ng konstitusyon na maggawad ng desisyon dito sa impeachment proceedings na ito. At kami po ay naniniwala na sa ebidensya po na aming ipinapakita, sa mga argumento po na aming sa pang-araw-araw po naming pinapakita rin po, no? Kami po ay naniniwala na sa bandang huli po ay mapapawalang sala po si Chief Justice Corona at mapagpapatuloy niya po ang kanyang trabaho na maglingkod sa Korte Suprema.
Karagdagan lang doon sa sinasabi niyang survey, no? Totoo yun na may survey na 47% na sinasabi guilty na siya, no? Tapos 43% na bukas pa at handang makinig, kung tama po ako. At may 5% na sinasabing hindi siya guilty. Una ho muna harapin natin yung realidad na ito po ay may ilang respondents. I think mahigit 1,000 po ito. Hindi ko hinahamon o sinusubok yung kanilang kapasidad. We know that there is a scientific way of doing it. Pero tandaan nyo po, malaki tayong populasyon eh. Although they could say that this is representative kung ano yung pulso. Pero po kung meron ako nakikita maganda sa mga nangyayari sa mga nakaraang araw o nakaraang buwan, is nung nagsimula po ito, ang marami po nagsasabi sa akin, kahit na hindi maganda yung kaso ng prosecution dyan, complaint, talo kayo. Ganun po ang sabi sa amin. Totoo po yun, nakakatanggap ako ng ganun. Ang maganda lang ho, nung binigyan kami ng pagkakataon, magpresenta, magsalita, magpaliwanag, ang tao medyo bukas ang isip. Kaya makita nyo, may 43% na bukas eh. Totoo po rin na meron na yung hindi pa nagsisimula, ang tingin ay convicted na yan. Meron din ho na hindi pa nagsisimula, ang tingin nila, acquitted na po yan. Pero I think a great bulk of our population, ng ating mga kababayan, ay naghihintay sa presentasyon namin. At gusto ko rin pong sabihin sa inyo na itong data na ito or ang survey na ito ay ginawa lamang. Kung tama po ako, korekin nyo kung mali ako, no? Noong hindi pa kami nagpipresenta ng ebidensya. So this was the general maybe observation of a number of respondents, more than 1,000, when we have not yet presented. So maganda indikasyon yon. Dahil handa silang makinig sa amin. Ngayon po, hindi natin alam kung sa mga susunod na araw ay ganun pa rin. If we are able to win them in our side, di rin po natin alam. Let's just wait for it.
Pero okay lang po ba sa inyo na yung senator judges, yun yung pagbasihan nila ng kanilang magiging boto, yung survey?
Siyempre hindi okay sa amin yun dahil nung bago sila maupo bilang senator judges ay nanumpa sila na gampanan ang isang obligasyon ng mga husgado. At isa dito sa kanilang oath ay yung to render impartial justice. Ibig sabihin, ang magiging basihan lang dapat ng kanilang desisyon ay ang ebidensya at ang batas at hindi ang opinion ng public o yung kanilang mga ibang konsiderasyon o nararamdaman. So, para sa amin, dapat ito yung mga gantong klaseng survey ay ang hindi maging basihan na magiging desisyon sa kaso na ito. At nung kanina, nung nakapanood ako, merong mga ibang na-interview senator judges at natuwa naman ako na ang mga sinabi nila ay walang halaga sa kanila ang mga survey na ito dahil in the end, ang magiging desisyon nga nila ay kung anong lalabas na ebidensya sa korte at kung ano rin yung nasa ating batas.
Karagdagan lang po, no? Matatandaan nyo, kung sakali pong sa naniniwala ko mabubuo ang prosesong ito, ito ang unang pagkakataon na mabuo ang proseso. Nananalig po ako na ito'y magpapatibay sa atin. Whatever the outcome is. And patience is very important. Knowledge is very important. And after we go through this, ang ating mga senator judges, we will have a maturity, a certain level of maturity bilang bansa. And yun ang maganda rito. Daanan po natin ito.
Question lang dun sa McKinley Hill property. Yung SPA na tinatanong ng presiding officer kahapon, duly notarized ba yon? At anong implication kung notarized siya o hindi?
Opo, malinaw po that the special power of attorney that was presented in yesterday's hearing, this was duly consularized. Meaning, sapagkat si Charina Corona po ay hindi niya naman po siya matatagpuan dito sa Pilipinas, siya po ay nasa Estados Unidos, sa California. So yung dokumento po na special power of attorney, ang ginawa niya po, pumunta po siya sa consular office natin doon, pinanumpaan niya po, inacknowledge niya na siya ang parehong tao na nanunumpa, at ang signature niya doon sa dokumentong yon ay kanyang signature. At yung consul po natin doon, na siya po ay inatasan ng ating pamahalaan na tumanggap ng mga consularization requirements po ng mga Pilipino na naninirahan sa ibang bansa. Sumumpa po siya sa harap niya at ito po tinatakan niya ng consular seal. At yun po ang tinatawag na proseso ng consularization. That would take the place of the notarization requirement if you will be here in the Philippines.
So redundant na i-notarize pa kung na-consularize?
Pag na-consularize na po doon, that is already an effective notarization, no? Insofar as to turn the private document to a public document.
So yun ang imamanifest natin later on the trial pag tinanong uli yan ng presiding officer?
Kahapon po, na-establish na po siya, no? So maganda po at nalinawan na po yung issue na yan.
Maraming salamat po.
Magandang hapon po. Bilisan na lang po namin. Anyway, nakita po natin so far yung mga witnesses since yesterday ay pareho pong taga-Ayala Land. Ang pinag-uusapan po yung columns. Yung testigo po kahapon at testigo ngayon, practically pareho po ang pwede nilang testify on. Sinasabi lang po namin is that the defense seems to be calling on witnesses which have repetitive testimony, testifying on the same facts that they seek to establish. So, ang nakikita po namin dito, talagang pahabain po at tila ito ng depensa. Sabi nga po kanina, kitang-kita po natin, yung sarili po nilang testigo ay pinapabalik po nila para magdala ng dokumento. Saan po tayo nakakita ng ganun? Kung nangyari po yun ng prosecution noong unang beses, na meron kami testigo at sasabihin namin, we apologize, the witness was not able to bring this document. Can the witness be instructed? Ginagamit ang Senado, tingin ko pagagalitan kami ng walang katapusan. Testigo nila yun. Dapat sila ang nagpapaproduce ng lahat ng dokumento. Hindi pwedeng pabalik-balik. You're only given one opportunity at binibigyan din kami ng isang opportunity para mag-cross-examine. But in fact, hindi na ho namin ino-oppose yun dahil lalo pa lang tatagal. Ang nakikita po namin so far, ang defense strategy po, kumbaga sa basketball, sometimes the best defense is offense. In this case, the best defense for the defense is to dribble the ball. Yan ang ginagawa po nila dito para po lalong maumayata ang buong taong bayan.
Pansinin na rin natin yung sinabi po nila nung ilang mga senador, I think sila Senator Drilon, Senator Osmeña, pati na rin po si Senate President, sinabi po nila na mahalaga po yung na in 2004, whether nakuha na po yung, o na-deliver na po yung condominium, hindi importante yun. Ang importante kung ano po yung idineklara ni Chief Justice Corona sapagkat naglabas na siya ng pera, so dapat may dineklara na po siyang asset. Sabi nga ni Senator Enrile, whether it's a receivable or a share or a condominium, yung importante ay dapat deklarado po ito. At klarong-klaro naman ho, mula 2004 hanggang 2010, ay hindi po naideklara ito. So, yun sa amin ay palagay ko parang sinadya na po na hindi isama dun sa kanyang SALN. Dun makikita yung sinasabi po ni Senator Miriam na may intent talaga na hindi isama yung kanyang ari-arian.
Well, syempre, just dagdag lang ng konti lang dun, no? Ito'y binring up ni Senator Gingona, yung usapin kung may note, nagbenta sila ng dalawang ari-arian para bumili ng ari-arian. So, ang tanong nga ni Senator Gingona, this happened in 2010. We're talking about the Ayala units on 2006. So, how can you explain that? So, ito yung mga nakikita po nating mga problema nila na lalong nagbabaon sa kanila. No? So, yun. Sa hinggil naman sa survey, nakita naman po natin na kung ano yung naging results ng Pulse, 47% believe that the Chief Justice is guilty, no? At tinatanggap po namin, although this is just a snapshot of how people see this impeachment case. And we are glad to note that 80% of the people are watching and listening to what is happening here. This shows that this case is important and this involves accountability.
Bakit itatago ni Chief Justice yung kanyang mga properties repeatedly?
Well, tingin ko gusto niyang, ayaw niyang i-reveal yung sources, yung pinanggalingan ng pinambili. Sapagkat yung SALN, alalahanin po natin, yan ay safeguard o kaya check and balance mechanism. Babantayan niyo po, masusubaybayan ng publiko yung paglobo o paglaki ng kabuhayan o ari-arian ng isang public official. So, pag hindi po na-ideklara ng tama ho yan, makikita natin na parang may tinatago po talaga.
Siguro yung dagdag na lang doon is, pag ayaw mong dineclare niya, maganda yung tanong po kanina umutang ng 11 million sa Basa Guidote, nilagay niya yun sa kanyang liabilities. Tapos yung 11 million na yun, that same year, nagkaroon din siya ng asset na 11 million worth nung binili niya yung La Vista property. So ginawa niya yun noong 2003, humiram siya ng 11 million, nilagay niya, bumili siya ng isang asset worth 11 million. So nagtutugma yung dalawa. Bakit for the subsequent years, bumili siya ng asset, hindi niya dinideclare? Kung sasabihin niya na ganun lang pala ang kailangan namin gawin, ganun lang pala kasimple para iwasan yung disclosure requirements ng SALN, bumili ako ng 20 condominium, lahat yan wag kong tatanggapin. I will just not accept it. I will keep writing the developer, may diferensya ito, nasaan yung tax certificate, wala pa akong kopya nito, wala pa akong kopya niyan. I'm able to avoid the disclosure requirements even if I had spent already 3.5 million for columns, 14.5 million for the Bellagio penthouse, and even if I spent 10 million for that Bonifacio Ridge property. In short, he spent 31 million